I could just whiz through some of my slides and then take questions, because I feel like we're in our third year of existence as Birthrights, and I think Rebecca and I have now reached a large proportion of the doula community. There is still more to get to, but I'm not surprised that many of you have heard us speak before. So as I said, we're in our third year. We set up in 2013. And as I suspect most of you know, we provide advice to women and maternity professionals, which includes doulas, about human rights in maternity care. We take those principles, which I know you as doulas feel to your core, those principles of dignity and respect, and we give them hard legal foundations, and we give you and midwives and doctors and women the tools to make sure that those principles are really respected in maternity care. And I always start this talk by talking about access to maternity care and how that framed the human rights debate. And actually 3 years ago, it was still really relevant. The notion that human rights was really just about access to maternity care and not about the type of care you got when you were in the hospital. But actually, as time goes on, it becomes less and less relevant, because I think people now accept that access is not the only issue that matters to women. And certainly in the UK, access is taken for granted, has been taken for granted since the establishment of the NHS. Although, of course, some of you will be aware of what's happening with migrant women's rights to NHS services. And so actually, the access point is coming back into play. There was a recent government consultation that some people might have seen, that migrant women who don't have documented status, essentially they don't have official leave to remain in this country, are going to be charged for access even to their GP. So not just for maternity care, but even to get that first appointment with a GP. So there are now real access issues in the UK. But what Birthrights always aimed to do was broaden that discussion about human rights and talk about what was really happening to women in those rooms when they were giving birth, to really shine a light on both the good and the bad practice that we all know happens in maternity care. And I've already mentioned the principle of dignity. That really is the principle that underpins everything that we do. And it was always very natural to me, because I'm a human rights lawyer, that dignity was something with real meaning. But I discovered pretty early on in this journey into maternity care that there was where people sort of laughed behind their hands when you talked about women's dignity in childbirth. And there's that famous phrase, leave your dignity at the door. And that somehow women in childbirth couldn't be dignified. That there was an inherent loss of status in being pregnant, in giving birth, in breastfeeding, that we're all reduced and diminished by those maternal processes. That was the assumption, I think, that pervades maternity care. And so what Birthrights is trying to do is reclaim the power of dignity, really reclaim female power, and say that actually you don't leave your dignity at the door. Your dignity is whole and intact, and it's promoted by pregnancy, birth, and the postnatal experience of women. And that it has real meaning. And we'll come on to the ways in which you can enforce the principle of dignity in the law. But the principle itself has such power, and it is, and I know those of you who've heard this talk before will have heard me say this, but it's a way of making sure that women are used as an end in themselves and not as a means to an end. To make sure that we see women, we appreciate that they matter in childbirth. We don't just see them as people who are making babies. And it does those important things for us, those two important things that are reflected in the law. It helps us to resist abusive treatment. So if you say that I have dignity, that I deserve respect, then you're also saying that you can't abuse me. And it enables you to assert your autonomy. So if you say that I'm a person who's worthy of respect, you're saying essentially that you're a person whose decisions are worthy of being respected. And we all know how much that matters in maternity care, when so often women's decisions are treated as irrelevant, simply there to be sort of placated but not really respected. And going straight to the legal power of these principles, the European Convention on Human Rights, which you hear about in the media as a kind of villain's charter, used by criminals and terrorists, actually gives us real legal teeth for these principles. So Article 3, no one shall be subjected to inhuman or degrading treatment. That's the abuse side. And people in NHS hospitals in the past have used Article 3 to make sure that their rights are respected. So in the Mid-Staffs case, although there were Mid-Staffordshire issues in the maternity ward, but by and large they were geriatric ward issues. And some of the families of patients who died on the geriatric ward brought claims under Article 3 of the European Convention on the grounds that their relatives had been abused, had been subjected to inhuman or degrading treatment. And then that second principle, that ability to decide for yourself what you want, has been reflected not just in human rights law, but also in the common law of England for centuries. It's one of our founding principles. And in the late 1990s, there was a kind of rash of cases where women were forced to have caesarean sections. And the Court of Appeal considered one of those cases and said that a woman who has mental capacity, and we can talk more about that if that's an issue that ever comes up in your practices, but a woman who has mental capacity can, for pretty much any reason, rational or irrational, decide whether or not to have medical intervention, regardless of whether she may die or the child she's carrying may die. Really fundamental stuff. And a second case went to the Court of Appeal in 1998. This was a woman with preeclampsia who declined to have a caesarean section, and the court said the same thing. Her right to decide what she wants for her body is not reduced or diminished merely because her decision to exercise it may appear morally repugnant. So it's been clear in English law for a long time that women have that capacity to decide for themselves what they want to do when they're pregnant and when they're giving birth. But some of you may have heard recently about a kind of spate of cases of women who lack mental capacity, women who may have bipolar disorder, they may have some other kind of mental health condition, they may have profound learning difficulties, who are being ordered by the court to have caesarean sections. There was another case a couple of weeks ago, and sadly, the protections for women in those situations are not anywhere near as strong as they are for those of us who do have mental capacity. So I don't know if anyone remembers that case of the Italian woman. It was a couple of years ago who came to the UK, and then it was dressed up as the Daily Mail as a baby snatching case, which probably wasn't quite right, but there certainly were real problems with the way in which she'd been treated. And when I read the evidence that had been presented by the obstetricians, and there was no midwifery evidence, when the evidence presented by the obstetricians to the court, they said that in labour, this woman who had quite serious bipolar disorder might dissemble. She might pretend that she wasn't in labour in order to trick the doctors. And that spoke to me of a residual paternalism and patriarchy that was being applied to a woman with mental health problems. You know, those of us who do have mental capacity probably won't have that level of kind of patronising obstetric opinion imposed upon us. But sadly, women with mental health problems may well. Yeah. So that case for me emphasised that there is still a proportion of the population who don't have the kind of rights that the rest of us take for granted, and we still need to look out for those women. And any woman who you may be caring for who has a history of mental health problems, even quite minor mental health problems, if she tells her midwife on the booking appointment that she has had depression in the past, or she's ever been on any kind of mental health medication, she may find that she's put on a kind of different path, and that assumptions are made about the kind of care she should be receiving or the kind of care she should be allowed access to. There may be assumptions made about the involvement of social services. It may be that she's threatened with an appointment with the safeguarding midwife, or that it's suggested that a social services file is opened in relation to her. So mental health remains an area where there are real difficulties with respect for women's rights. So that principle of choice is reflected also in the European Convention on Human Rights in Article 8. And those of you who've heard me speak before will have heard me talk with great excitement about this Czernovsky case. The Czernovsky and Hungary case, which came out in 2010 and recognised by the European Court, recognised that women's choices about childbirth are protected by the European Convention. And I got very excited about that case when it first came out, but sadly there has been a subsequent sort of negative development, which some of you again may have heard about, called Dubska in the Czech Republic, in which the Czech government went back to the European Court and said that women's decisions in childbirth shouldn't be protected in the way that the court had said, and the court agreed with them. And we're now awaiting, long awaiting, the judgment of the final Court of Appeal in the European Court to see whether how the court resolves the difference of opinion between those two decisions. Both of those cases were about home birth, but they apply to all decisions in childbirth. If your decisions are protected by Article 8 of the European Convention, then any attempt to interfere with your decision, to limit your decision about where you give birth or who is with you when you give birth, whether you can have a doula with you as well as your partner, etc. Any decision about childbirth, any decision to limit your choice, must be justified, and that justification process is quite onerous. So there must be evidence, and it must be a proportionate decision. So it's really important that the court recognises the full power of Article 8, and when the judgment's handed down, we will write something about it on our website. Just one that I think is a recent decision that might interest some of you, Konovalova in Russia. This was about a Russian woman who gave birth in a teaching hospital, and she was told that because she was in a teaching hospital, she had consented to having medical students present during her labour, even if she objected at the time. She was in the second stage, she was having quite a prolonged and difficult second stage of labour, and a whole group of medical students turned up in the room, and she said, well, can you go? I don't want you to observe this, and they refused. So ballsy woman that she was, she went all the way to the European Court of Human Rights, and the court said that any medical intervention, and it counted the presence of medical students as a medical intervention, any medical intervention, you had to obtain a woman's consent. And I know in the UK, from births that I've attended and from what I've heard from women and doulas, very often have midwifery or medical students in the room when a woman's giving birth without even informing the woman that they're not qualified. That seems to me quite a common occurrence. And following this decision, all hospitals should be aware, actually, that women should be told. And I suspect the vast majority of women will say, fine. But some may feel quite strongly, actually, that they don't want unqualified professionals there to observe. So all of these principles that I've been talking about in the European Court just come through into English law through the Human Rights Act. And a question that I've been asked increasingly is, well, hasn't the Tory party and Tory government committed itself to repealing the Human Rights Act? And the answer is yes, but whether they ever get round to doing it remains to be seen. And even if they did, it wouldn't affect the kind of principles we're talking about. So we're on pretty safe ground. And we, while it would be a field day for lawyers if they repeal the Human Rights Act, and it's not going to affect maternity rights in any profound way. Yep. If we leave the European Union, so the Human Rights Act and the European Convention on Human Rights are totally distinct from the European Union. And a mistake that's often made in the press, and you will see the Daily Mail referring to the European Union Convention. The European Convention on Human Rights comes out of the Council of Europe, which is a much broader group of countries, includes Russia and Turkey and some pretty unsavoury places. Whereas the European Union is obviously the political and economic union that contains only the member states in sort of mainland Europe. And so if we were to leave the EU, there wouldn't be any effect on our membership of the Council of Europe. But the Council of Europe has said that if we were to leave the EU, they would be deeply concerned by our ongoing commitment to human rights, and so it might well speed up the process of repealing the Human Rights Act. And some Conservative politicians have even suggested that we would pull out of the Council of Europe, which would be a truly remarkable decision. I think we in Uzbekistan might be the only people who were out of it. So if we did that, even in those extreme circumstances, we would still have those common law protections that I talked about, and we would also pass our own Bill of Rights, which would include the rights that we've been talking about. So we don't need to worry too much in the maternity context about the loss of rights. I mean, there are obviously lots of other important political issues around Brexit and pulling out and repealing the Human Rights Act. But thankfully for maternity care, all the things that we talk about will remain the same, although we will make a big fuss about it should it happen. And this, I think about a year ago, I was giving one of these presentations and a kind of penny dropped for me, and that was that I was talking about the kind of principles of dignity, you know, it's like a kind of lofty legal principle and these cases and so forth, but does it actually matter? How does it connect to women's kind of lived experiences of maternity care? And it prompted me to try and match up the clinical research with the principles. And lo and behold, what feels instinctively right, I think, to all of us is actually reflected in the research, and that's that the two factors that consistently are reported to matter to women in childbirth are supportive relationships with health professionals and a sense of control over the decisions that are made in childbirth. So regardless of the birth outcome, whether the woman has a normal vaginal delivery or a caesarean section or whatever, the two things that she reports matter to her are the supportive relationship and the sense of control. And if you think back to the first few slides that I showed you, the principles of dignity are respectful relationships and autonomy. So the very principles that dignity is seeking to protect are the things that matter to women. And that brought me great joy because it meant that the work we do actually can make a difference. Fetal rights. This is a really vexed topic. This audience is not going to be as difficult as some audiences I've spoken to about this. I was in Ireland a couple of months ago talking about fetal rights, and you can imagine the circumstances, they're very, very different. The political scene is very different, and their constitution explicitly protects fetal rights. Here in the UK, there is no legal protection for a fetus before it's born. And it doesn't have any separate right that it can exercise against its mother. So that's the kind of basic legal position. But we all know that, I think, emanating from the United States, and perhaps also from the kind of Catholic parts of Europe, there's a growing sense that the fetus is a separate entity, that it has its own identity. And I think that's compounded by the use of scanning technology and also the notion of fetal medicine, and the amazing work that can now be done to heal babies in the womb, and so forth. And I think all of that contributes to a real sense that somehow the mother and the fetus can be separated. And that has fed its way into the medical profession. And so you have these ludicrous statements by supposedly respected journals, AJOG and The Lancet, which suggest that somehow the clinician has an obligation, a separate obligation to the fetus that can override their obligation to the mother. So you have Dr. Chevenak, who's a renowned Catholic obstetrician and the leader of the kind of anti-home birth movement in the United States, saying that physicians and obstetric providers have an independent obligation as a matter of professional integrity to protect fetal and neonatal patients. And of course the question is, protect them from whom? Well, I would say protect them from you, Dr. Chevenak, but he would say protect them from us and you, doulas and midwives, and the mother herself. And then The Lancet, you might think more sensible, but sadly not. Women have the right to choose how and where to give birth, but they don't have the right to put their baby at risk. Well, you can see that that is plainly ludicrous and illogical. But that is the cultural context in which you're all working. There was some very interesting research in Australia that came out in 2013, just at the time that Birthrights was founded, in which the researchers, including some lawyers, asked questions of midwives and doctors, not doulas in fact, but just midwives and doctors, about their understanding of their professional accountability. And they wanted to know whether these maternity professionals felt they could override women's choices in childbirth, and in what circumstances could they do that. And the majority of them said that no, they didn't think they could, but then when they were asked, well, what if there's a problem with the fetus, what if there's a safety issue, then would you override the woman's choices? And the majority of the doctors and about half the midwives said, oh yes, then we would. Well, those two things are obviously inconsistent in the same way that the Lancet quote is inconsistent. But the researchers went a bit further and tried to probe why would midwives and doctors be feeling that way. And the answer, of course, was that they believed themselves to be legally accountable for what happened to that mother and child in childbirth. And if you believe yourself to be legally accountable for the outcome, then you will want to step in when you think there's a risk, right? And you'll probably have a pretty low threshold for what that risk is. But are doctors and midwives legally accountable for all outcomes in childbirth? No. They're only accountable for their own practices, so they can be negligent, and if harm results because of their negligence, then yes, they are legally accountable. But if a baby is injured or dies, or a mother is injured or dies in childbirth and there hasn't been any negligence, then the midwife and doctor are not legally accountable for the outcome. And so that really overbroad understanding of their responsibility meant that they were interfering too much in women's choices. And I think the same thing is true in the UK, but I think in the UK, the gloss that I would put on it is that they're afraid not only of negligence cases and of being legally accountable in that way, but they're afraid of disciplinary processes, both within the hospitals, so management investigations, but also supervisory investigations and referral to the NMC and GMC. So in the UK, our regulatory structure is actually imposing a kind of punitive sanction and creating a culture of fear in the NHS, which is causing midwives and doctors to lower their threshold for an assessment of risk and to step in when it's not necessary, and then to cause more harm. So that's what I think is happening in the UK. That, I think, was the subtext of the recommendation in the maternity review for a rapid redress scheme, and we can talk a bit about that in a minute if people are interested in the maternity review. But that culture of fear is something that I think you as doulas are battling all the time. And I think one of the ways that we can help you in that fight is to explain to midwives and doctors that actually the woman bears responsibility for her choices. And if she makes a choice, she must live with it. And if that choice turns out to cause harm, and the doctor and the midwife have stood by her and they haven't been negligent, then it's on the woman's shoulders. And that's to treat women as adults. And that's how it should be. But I think many midwives and doctors don't see it that way. This is kind of slightly depressing list of healthcare practices that violate human rights, and I'm not going to go through them all. But there are just a few that you as doulas might be particularly interested in. Disrespect. And I've included in there everything from verbal abuse, which hopefully you don't see too much of, through to shroud waving, which you probably see all the time. So women who are told that yes, if they birth their breech baby vaginally, the baby will die. Not, there's an increased risk and the increased risk is this. And actually the evidence for that is pretty poor, and a lot of places are changing their practice and so on. No, the baby will die. That's shroud waving. Non-consented care, procedures that are performed without adequate intervention. When was the last time you were with a woman and you truly felt that she had been provided with adequate information about her care? How many times as doulas have you really felt that a woman's been in possession of all the relevant information? Pretty rarely, I would have thought. Which has a legal consequence. It means that if the woman agrees then to that medical intervention, she hasn't truly given her consent, because you can only give your consent with full knowledge of the circumstances and the alternatives that should be available to you. And those alternatives, for example, post-dates induction. A woman who goes in for a post-dates induction, is she told that she has a 40% chance of an emergency caesarean? No, probably not. But those are the statistics at the local hospital here in Hackney. Post-dates induction lead generally to about a 40% emergency caesarean rate. Is she offered an elective caesarean as an alternative? No. So that woman is effectively disempowered. And if she has an emergency caesarean, which she is likely to do, how will she reflect on the decision-making about the induction? And will that decision-making lead to trauma? Quite possibly. Depersonalised care, another one with which you'll be very familiar. Birth centre admissions policies. Women with high BMI who are told, well, we have a cut-off of 35. I know some places are lowering it even more. And if you have a BMI at that threshold, no, that's it, that's our policy, you can't access the birth centre, no, you can't be in a pool, etc. Ultimately just telling that woman that she's too fat to matter. Well, those policies are unlawful. You can only apply a policy like that with regard to individual circumstances. So yeah, you can have admissions criteria that say we admit women with a BMI under 35, but we will always consider the individual circumstances of any particular woman's case. So she may be a multip who's had perfectly straightforward previous births, and she's got no other risks in her pregnancy. Why can't she use the birth centre? What evidence-based justification could there be for that? And we also know the evidence has come out recently that women with a high BMI who have previously given birth have a lower risk than primips who have never given birth. And yet primips are allowed onto the birth centre. So it's completely nonsensical. And it's up to you guys to challenge those policies or to enable the women you're caring for to challenge those policies. And finally, discriminatory care and high BMI, obviously, those sorts of policies are a form of discrimination, as are policies based on age. So women who are told, yeah, if you're 40 or over 40, you're induced at 40 weeks. A great one from Homerton recently was, if you've had any kind of assisted conception, then you have to be induced. Really? Explain to me why a turkey baster is any different from a penis, because I don't see that leads to any higher risk in childbirth. Maybe I'm missing something, but anyway, I did say that to someone there and I didn't get a good reception, but you know, they have to be evidence-based. You can't just make up a policy because you want everyone to be induced and that's your way to do it. So, how do human rights improve maternity care? Well, through those principles that we've been discussing, you have to provide personalised care. Those rigid institutional policies don't take account of individual women. You have to have respectful care, be treated with kindness and compassion. And those women who have specific vulnerabilities, be it that they're 40, be it that they're a migrant without regular immigration status in the UK, be it that they've got high BMI, whatever it might be, they should not be stigmatised or subjected. Sorry, that was my husband saying he nearly got run over, but he hasn't. I'm going to turn my phone over. That he shouldn't be stigmatised or subjected to discrimination. So those are the ways in which human rights can improve maternity care, and those have implications for you when you're looking after women. You can feel empowered by the principles that we give you to know that you're in the right. To know that when you have an instinct that something's wrong here, that this woman is not being treated in the way that she ought to be, you can come to us or go to our website and seek our advice and use the principles that we have set out and know that the law is on your side and know that you can stand up for those women in a positive and powerful way and that you are not alone. That we are always there over your shoulder, and that the more doulas we reach, the more midwives and doctors we reach, the more these principles become part of general understanding, the more we change culture, and hopefully over time, eventually, we change practice. Just briefly on birth partners, because it's obviously very relevant to you. I'm asked quite regularly whether women have a right to choose their birth partner. And remember that Article 8 of the European Convention does give women the right to make choices about how, where, with whom to give birth. And so that, of course, includes the right to choose one or more birth partners. Article 8, as I said, is a limited right. You can be restricted if there's a legitimate, proportionate reason to do so, if there's evidence. We'll go back to Homerton because it's the hospital I know, and it also seems to be a place full of irrationality. When you go into their reception area, I don't know if it's still there, I suspect it is. When you go into their reception area, there's a really lovely, friendly, welcoming sign that says, "Only 2 birth partners allowed, no swapping." Great. And there it is, not, come here and give birth in a lovely, friendly environment. Just don't even think about swapping one of your 2 birth partners, right? And I think it might even say for health and safety reasons. Really? Okay. So, again, they're entitled to have a policy, but their policy has to be reasonable and it has to be applied fairly to the individual woman, taking account of her circumstances. She's having a very long labour. Her mother-in-law wants to swap out with her doula or whatever it might be. Really? Is it fair to say to that woman and to her birth partner that they can't do that? Clearly not. And you would find support in saying that women do have the right to make choices in childbirth, and if you're going to limit them, you need to have a good reason to do so. Obviously, in an operating room, there might be much better reason for saying that there are higher infection risks or whatever it might be, and so we have to limit the number of people in the operating theatre. Although even in that context, you see how many people come and go from the operating room and you think, really? Yeah, I never buy it myself. Another question that comes up in the doula context is the question of consent. Can doulas or women's birth partners give consent on a woman's behalf? And the answer to that is obviously no. As long as the woman has mental capacity to make her own decisions, then she must do them for herself, and nobody else can speak for her. But the reality is, of course, that you will advocate for a woman. But that line between advocating and actually giving consent on her behalf is a delicate one, and you will need to be aware of that. And finally, free birth, one again that's raised quite frequently by doulas and midwives as well. And the question that we're asked is free birth illegal? And it always surprises me that anyone could think that it was illegal for a woman to give birth alone. But you'd be amazed how many midwives think it's illegal, and how many women have been referred to social services and the police on the basis that it's illegal, and then how many police officers also seem to think that it's illegal. So despite the fact that I think it's completely ludicrous, obviously there's some pretty profound misunderstandings out there. Free birth is not illegal. It is in fact perfectly lawful for a woman to give birth by herself, and there's no legal basis on which anyone can prevent her from doing so. The only wrinkle is that if she has a doula with her and the doula provides any kind of care that counts as attendance in labour, then the doula could be prosecuted essentially for holding herself out as a midwife. And so you just have to be careful as doulas that you're not offering midwifery services, essentially. Unfortunately, the nursing and midwifery order that creates this offence doesn't actually specify what attendance means. It doesn't give any examples, and there haven't really been very many prosecutions, so it's quite hard to know. But I would advise that anything like palpation or auscultation, even potentially cutting the cord, could be midwifery functions. So you just want to be a little bit careful around that if you are attending a woman who is free birthing, although I know that Doula UK has policies on that as well, and I'm probably entering a treacherous area. I have some case studies here, but I think instead of case studies, I will just take questions from people, because I suspect a lot of the things in our case studies you would want to ask anyway.
I've got two questions. Sorry, everybody. The first question I've got is, if a woman's attempting a birth with a birth partner who's not her next of kin and it's an emergency, and I've been asked this week, so what happens then? Is there a form? Is there something they can do to make that birth partner, not the doula, but the dad?
So if the woman loses consciousness, and that's really what you mean by an emergency, because there may be an emergency but she is totally conscious and able to make her own decisions, but say she has a cesarean and starts to bleed out, doesn't come around from the general anaesthetic, and they have to make a decision about hysterectomy, that sort of thing, which must be pretty rare. Yeah, so first of all, it's rare, but the answer is that the hospital will only hear from the next of kin about the woman's wishes unless she's made an advance directive. I generally, women sometimes ask me whether it's worth making advance directives in maternity care, and unless they're extremely anxious and it would give them real peace of mind, I don't think it is worth going through that process.
And the second question, and I don't know if this is national or just Wales, we've got such a problem with women being high risk out of the NLUs that I'm surprised that anybody's even classed as low risk and allowed to give it birth anywhere else. Our local NLU is not getting enough birth, so they think they're closing it, and they're building one in the next trust, but I don't even know who they're going to send to it, because between
well, there's never been a legal case in which a woman's gone to court and challenged a birth centre admissions policy, because you can imagine most pregnant women aren't going to be up for going to court. But certainly the principles that I've been talking about mean that though there has to be evidence behind an admissions criteria that excludes a woman. So borderline high blood pressure, there isn't any evidence. Well, it doesn't exist, first of all. And second of all, there's never evidence that actually increases risk in birth. Same with BMI. As I was saying, the multip with a high BMI versus the primary. So you, at the MSLC, can challenge on evidence for evidence-based reasons, but they can also challenge the kind of application of a blanket policy. So if women at their booking appointments, or if at their 32-week appointment are being told, no, that's it, you can't go to the MLU, the midwives need to be retrained, essentially, to understand that they can't simply give a blanket no to any woman who, has any risk. And so I suppose that's where Birthrights comes in, and we will be doing some training in Wales shortly. Yes. But the difficulty really is that the midwives and doctors are being put under pressure by the trust lawyers and the powers that be to try and force women into what is perceived as a safe environment on the labour ward, with no care for the consequences and no real appreciation that actually it causes more harm than it does good. So it's a battle we all have to fight, and we do it woman by woman by woman, midwife by midwife. But that's the only way to fight the battle, because changing culture takes time.
If we vote to come out of the EU, will the face of birthrights regarding European rights?
So, as I said before, the EU doesn't have any effect on the European Convention. So all of the rights that I've been talking about come either through the European Convention, which we would still be a party to, and the EU would have no impact on that, or they come through our common law, which is the law of England and Wales, which has been around since pretty much William the Conqueror. So the common law rights about consent and being able to resist forced medical interventions would never change, regardless of what happened to the Human Rights Act. So it doesn't really have that much impact. I mean, I have pretty strong personal views about Brexit, which I'm sure you can imagine, but I don't think that Birthrights needs to take a position on it at the moment. The difference would be if we came out of the EU and then there was a campaign to remove the Human Rights Act, or to come out of the Council of Europe and repeal to no longer be party to the European Convention on Human Rights, then we would make a real song and dance. But rest assured that actually the practical impact, I don't think would be that great. So although we might get, we might have a campaign around the Human Rights Act, the reality is that those rights will be protected whatever happens to the Human Rights Act and to the European Convention. Can I just say finally that we're in the middle of a fundraising drive which Rebecca there in the red dress is leading, and we are trying to up our number of monthly donors, and the work that we do simply can't be done on the funding that we have at the moment. We want to reach every midwife and every doctor in the whole of the UK, not just England but also Wales and Scotland, and we would be so grateful if any of you felt able to donate a monthly sum, however large or small, to help us do that work. We haven't previously been asking for money in any very active way, but we're changing that now because we're so ambitious about what we want to do, and also because Rebecca is now our salaried director and she has grand ambitions for Birthrights.
Not grand ambitions for a salary.
Grand ambitions for Birthrights. She has, she really should have grander ambitions for her salary. So thank you very much, and I will be around for about 10 minutes if people want to talk.